South Africa's information regulator is set to ban the processing of some personal information without prior permission. It's activating its power under a law from 2013. This ban kicks in on Thursday, the 1st of July, along with other parts of the Protection of Personal Information Act. You'll know it as POPIA or POPIA. Well, let's get a breakdown of what this actually means for the layman like you and I, and what this new data privacy rule entails. Director of Data Privacy Practice at Werksmans Attorneys, Ahmore Burger-Smidt. Ahmore, good morning to you. And I know that the law is very complicated. It delves into a lot of detail. It's very granular. But come Thursday, for someone like me, what is going to change in my life? What do I need to look out for?
Morning, Gareth, and thank you for having me. I don't know what happened, but your voice is very faint suddenly. But I gather that the question relates to, so what changes as of Thursday when the Act comes into full operation and effect? Well, I would suggest the most important thing that we need to realize, each of us as individuals, is that companies will have to be in a position to answer to the rights that we as data subjects are afforded in terms of the Protection of Personal Information Act. So the Act provides for responsibilities on the side of companies, or amongst others, to be able to tell an individual what personal information of the individual the company holds. An individual is referred to as a data subject. Now, I want to remind your viewers that personal information relates to any and everything that you can use to identify an individual. So not only do you have the right to ask, but what personal information of mine do you hold, but also to say, I don't want you to process my personal information, and I withdraw my consent for a company processing my information. So those are two of the core rights that a data subject will have, in addition to the right to say, but you've got the wrong information about me. I need you to correct my information, which is very important in the days and the times we live in, to make sure that companies have your correct information. And there's a duty on companies to then adhere to this request.
So as of Thursday then, so there's two things that I think many people were wanting me to ask you about. Come Thursday, there's two things that annoy South Africans. Well, one thing annoys South Africans, one thing annoys me. One thing that annoys South Africans is call centres. Help me understand, does this in any way, Ahmore, affect how call centres and how those companies are getting our details? We've heard rumours that it's banks, insurance companies, etc., selling our data on without our consent. Is that something that's going to be addressed by this new law coming in?
Yeah, there are two things that you've raised. The selling of the data, which is an important element, and then whether you'll never receive a call from a telemarketer again. And that is indeed a hot topic on everyone's lips. Now, in the first instance, the selling of the data and the building of massive databases, we need to remind ourselves that data has got value, massive value. It's referred to as the new oil of the economy, of the nowadays economy that we live in. So to sell data, you need the consent of the data subject. So that's one area of focus. So you can't just, as years back, decades back, collate information from wherever you can find it and on-sell it to marketers. The second important point is actually bad news for all your viewers, in that the definition in the Protection of Personal Information Act, when it comes to direct marketing and then specifically electronic communication, does not refer to telemarketers. So it refers to SMSs or automated calling machines, those annoying calls you get when you answer and then there's silence and the next minute this recorded voice starts speaking to you. That won't just happen in future. The legislation specifically says I can advance direct marketing and unsolicited direct marketing to data subjects if I've got their consent, i.e. I agree to receive that direct marketing initiative, or then alternatively, I'm an existing customer of the company that engages in the direct marketing. And if I'm that existing company marketing to my customer base, I must be sure that the data subject will always have the ability to opt out, to say, stop it, I do not want to receive this
It's
direct.
really funny you actually said that, because I'm not even making this up. I just got a message, there it is, there. While you and I were talking, apparently I can stand a chance to win 150,000 Rand and a bunch of kids' stories and shows while I'm on air with you. I mean, you can't make this sort of stuff up. Final question to you, more very, very quickly, if we could. WhatsApp. A lot of people were concerned about WhatsApp come the 1st of July. Everybody left WhatsApp to go to Telegram. In the last minute I have with you, what does that mean for people who are admins and companies who run WhatsApp business accounts? Does this affect that at all, or is that an entirely different discussion?
I think, to a sense, it's an entirely different discussion. If we look at WhatsApp and their terms and conditions and their privacy policy, there's a long road to be walked with that, with the information regulator indicating that they're engaging with WhatsApp, and I think that this space will definitely change in future. But again, it all centers around whether I want that direct marketing, and that I, as an individual, as a data subject, always have the right to say, no, stop it, I don't want to receive it.
Well, I appreciate your time, and I think once we get to that longer discussion about WhatsApp, hopefully, Ahmore, you'll make yourself available for that. It's been wonderful talking to you. Director and Head of Data Privacy Practice at Werksmans Attorneys, with one of the most beautiful views in Joburg, I might add, Ahmore Burger-Smidt, joining us here on eNCA.